past Tuesday, a verdict was handed down in the Carmelo Anthony case. It was called Texas Justice. But did they get it right? We're going to talk about that and a whole lot more on this episode of Charlie-Crime-buster. What some people are calling the fastest minutes in podcasting.
The views and opinions expressed in this presentation are solely those of the individuals participating and do not represent those of city, county, state, or federal law enforcement agencies, nor sponsors and platforms of this presentation. The Charlie-Crime-buster name and all forms and abbreviations are property of its owner, and its use does not imply endorsement of or opposition to any specific organization, product, or service. All individuals described or mentioned in the presentation should be considered innocent unless or until found guilty in a court of law. This presentation contains adult subject matter. Listener and viewer discretion is advised.
Well, hello and welcome to today's program. Glad to have you. We've really got a pretty tremendous program for you today. A lot of questions. A lot of people are upset and some people are satisfied. I would have to say nobody's really satisfied. But there is an enormous amount of attention on this particular case. Before we get right into it, let me take a moment to welcome you to the program. Whether you're a seasoned listener or a first-time listener, please do us a favor and write a review. Give us a 5-star review if you would. That'll help us get the program out to more people. Don't forget to hit that subscribe button. That way you will be notified every time we drop an episode. I want to also ask you to look at peacemakernetwork.com. That's our sponsor here at Charlie-Crime-buster. There you're going to read about the brave men and women who run toward danger instead of away from danger. We're talking about the military, first responders, and law enforcement. Read all about that at peacemakernetwork.com. If you'd like to reach out to us with suggestions about other programs you'd like for us to cover, other cases perhaps, or maybe you just want to ask a question, maybe you want to lodge an objection, you can disagree with us here at Charlie-Crime-buster because it is a safe spot. To do that, reach out to me personally, charliecrimebuster at gmail.com, charliecrimebuster at gmail.com. All right, let's get right into our case today. Last Tuesday, a verdict was handed down in the Carmelo Anthony case. He was found guilty, sentenced to 35 years. The question is, though, do you have a right to defend yourself? And if you have a right to defend yourself, to what extent should you go? And in this particular case, does race play a part in this or not? Those are all questions we're going to talk about on today's program. Well, first, let's start by saying that this particular dispute caught everybody's attention. It did capture national attention. Now, keep in mind that in the course of this case, there were others that were murdered. There were others that claimed self-defense. One just happened here in Daytona just a week ago, where someone shot someone 9 times and said they did it in self-defense. And that particular situation, it was ruled self-defense. But this one caught our attention. It was a dispute between 2 high schoolers that lasted only a few seconds. Yet the outcome, one teenager dead, the other facing years and years in prison. Carmelo Anthony, 19, was found guilty this past Tuesday of a murder over the stabbing of another teenager. This happened in Frisco, Texas, and it was Texas Justice. Did they get it right? There in Frisco, Carmelo Anthony stabbed 17-year-old Austin Metcalf during a high school track meet. Austin died of his wounds. Carmelo's lawyers argued self-defense. Even though Carmelo was 17 years of age at the time, he was actually tried as an adult. Now, my friend, I got to tell you, in many ways, this is a very tragic story. Austin Metcalf is dead. He will not graduate. People will not celebrate his graduation. He will not marry. He will not have children. He will not give to his parents grandchildren. His loved ones will not see him alive again on this earth. And yet, there's another family, Carmelo and his family. They face tragic consequences as well. Now, Anthony Carmelo was born in Baton Rouge, Louisiana. He moved to North Texas in 2021, according to Fox 4. He is the oldest of 4 children. Family representatives say that he attended the Fresco Centennial High School football, and he played football, and he participated on track and field teams. Away from the school, he had a job. He worked at Foot Locker for 2 years, as well as for the H-E-B supermarket chain. And this young man had no criminal record prior to this deadly incident with Metcalf. Now, earlier I mentioned that this case, among other cases, rose to national prominence. It has interesting issues for all of us. Issues about self-defense, youth violence, race, media coverage, and, of course, Texas justice. It all started back on April the 2nd, 2025, at a stadium in Fresco, Texas. It was a cloudy, rainy afternoon in Texas, North Texas. The school fans there and teenagers sat in bleachers at the mid-season track and field competition. Austin Metcalf, he too, 17 years of age, at Memorial High School in Frisco. He was sitting in his high school's tent there when he spotted Anthony, a 17-year-old from another high school, sitting under Metcalf's school tent. Now, according to witnesses, Metcalf asked Anthony to relocate and sit in with his own team. Anthony refused. Metcalf grabbed or pushed the teenager. Anthony then reached into his backpack, pulled out a knife, and stabbed Metcalf once in the chest before running off. Tragically, Metcalf died on the scene. Anthony was arrested and immediately escorted to the Collin County Jail. A Memorial High School athlete testified in the trial that students repeatedly asked Anthony to leave the team tent, and that Anthony allegedly challenged the students to a fight. Another witness said that Austin declined fighting him, telling him he was not going to fight at a track meet. Moments later, the same student said that he heard Austin yell he had been stabbed. Then students fled the area. A second 16-year-old student from the class of 2027, he told the court that immediately after the attack, he said the final words were, he fucking stabbed me. Another 18-year-old on the stand broke down in tears as he recounted the chaos of the moment, testifying that he heard Metcalf screaming for help. Witnesses also stated, on trial, under oath, that they had asked Anthony to leave the tent as many as 15 times. The arrest report, it noted that Anthony, quote, grabbed his bag, opened it, reached inside it, and said, "Touch me and see what happens." Austin then stood up, pushed the male to get him out of the tent, according to the arrest report. The witnesses told police that Anthony then reached into his bag, took out a knife, and stabbed Austin. The witness, one, told the officer that Anthony had left the scene after the stabbing. And, unfortunately, Metcalf, only 17 years of age, died in his twin brother's arms. Folks, this is a terrible situation. A terrible situation of a minor confrontation that escalates into a life-altering tragedy. That's why in Florida here, our cops are getting very serious about charging people who are instigating and involved in road rage incidents on our highways. Now, while we can say, teens should not behave in the ways that cause this tragedy, yet adults do this same thing every day in this country, and it is dangerous. Folks, all of us, in all of these situations, whether on the road, or in a tent at a sports activity, or at a store waiting in line, or getting fast food, we all need to take a breath. We need to chill out, and we need to avoid these kinds of confrontations. These confrontations do change lives. Now, after this incident on April 2nd, 2025, Anthony was arrested on the scene, and they charged him with murder. Anthony acknowledged that he stabbed Metcalf, but, listen to this, he claimed he acted in self-defense. Now, after Anthony's arrest on the 2nd of April in 2025, a judge then set his bond at $1 million. Then there was a hearing. It was on April the 14th. There, at that hearing, the judge agreed to reduce the bond. He reduced it down to $250,000. He went from $1 million to $250,000, and he placed him under house arrest at his parents' home with an ankle bracelet. He was released from jail that very same day. But then on June the 24th, same year, 2025, Collin County District Attorney Greg Willis, he announced that a grand jury met, and they indicted Anthony for murder. This murder is a first-degree felony with a possible sentence of anywhere from 5 to 99 years of life, or life in prison, even without the possibility of parole. Willis said his team worked to present the evidence in the grand jury for weeks. But now keep in mind, my friend, a grand jury indictment does not mean that the person is guilty. The grand jury indictment only means that there is enough evidence to charge that person. And the grand jury did meet, and they did come up with an indictment that charged him with murder. The reason they charged him with murder was because they concluded that there was probable cause that he, listen carefully, intentionally or knowingly caused Metcalf's death by stabbing him during this altercation there at that high school track in Frisco, Texas. Witness statements, physical evidence, and Anthony's admission that he stabbed Metcalf was what gave them the basis for the charge, according to prosecutors. Even though Anthony's defense has argued from the very onset that he acted in self-defense. Now, there's something else about this case. He was actually charged as an adult. And that, my friend, is primarily a matter of Texas law. Anthony, just like his victim, was 17 years of age at the time of the incident. But in Texas, 17-year-olds are generally prosecuted in the adult criminal justice system rather than the juvenile system. And because of his age then, because of Texas law, prosecutors do not need another special transfer hearing to argue that it should be moved to an adult court. They can automatically take it to adult court. In a case like this, usually the key legal question always boils down, what did the defendant intend? What did they reasonably believe? And whether that force was justified. Now we know he was charged with murder. Under Texas law, murder involves intentionally or knowingly causing someone's death or intending serious bodily injury and committing such an act that is clearly dangerous to human life and causes death. The prosecution's theory, very simple, that Anthony intentionally stabbed Metcalf in the chest with a knife during the confrontation. That action caused Metcalf's life, Austin's life. A deliberate stab with a deadly weapon can support a murder charge, because then a jury may infer an intent to cause death or serious bodily injury. Now, they could have went for manslaughter. Manslaughter is a lesser offense that generally involves causing death recklessly rather than intentionally. Did you hear that? Recklessly other than intentionally. For example, you're celebrating on the 4th of July. You fire a gun into the air. That bullet finds a place to go. By the way, when you fire a gun into the air, it's going to come down. It could come down and hit somebody, and it could kill somebody. In that situation, a manslaughter charge is equivalent to the law of Texas or many other places. It also would involve maybe engaging in some kind of dangerous conduct and disregarding that risk. A defense attorney also can argue for not only manslaughter, but they can argue for self-defense. And self-defense, my friend, is not a separate crime. Self-defense is literally legal justification for using force. Now, if you listen to us on Charlie Crime Buster, you know that we are very, very strong believers in a person's ability and right to defend themselves. But deadly force has a stricter requirement. In deadly force, a person must reasonably believe that deadly force is immediately necessary to protect against one's use or attempted use of deadly force or certain serious crimes. Many times it doesn't mean that you find somebody shove you and then you turn around and kill them. In Anthony's case, the defense argued that he feared for his life and he stabbed Metcalf in self-defense during the confrontation. The prosecutors, on the other hand, come back and say that those facts do not support a reasonable belief that deadly force was necessary. And in this particular case, we now know, as a result of the jury's verdict this past Tuesday, that they agreed with the prosecution and they convicted him of murder. Now, a murder charge at the beginning of a case is an accusation. So then the jury has to meet together. They have to decide what facts actually occurred, whether the prosecution proved the elements of murder beyond a reasonable doubt, or whether the defenses, such as self-defense, would apply to it. In this case, the jury found that the prosecution met its burden and that the self-defense claim did not justify the killing, which resulted in a murder conviction of this 17-year-old kid who stabbed another 17-year-old kid to death. Now, in just a moment, we're going to get into what really happened in that jury room. Why did they come up with that particular verdict? But now it's time to pause, take a deep breath, and just relax for a moment while we share with you Charlie Crime Buster's Crazy Crook of the Week. Well, in our Crazy Crook story today, a Tennessee man with outstanding warrants, well, he ended up finding himself into pretty deep trouble after officers followed him through a rather unusual escape. This crazy crook went by the name of Daniel Poor, and he had a rather poor, excuse the pun, reaction to officers trying to serve him outstanding warrants back on Tuesday, June the 9th. When he didn't comply, well, the officers they took chase of him. According to the official report, Poor was wanted for various reasons, including criminal conspiracy, burglary, contempt of court. While traveling toward a residence to locate him, to serve him the papers, the deputies then spotted him leaving a driveway in a black Toyota. Well, deputies attempted to initiate a traffic stop, but some of these crazy people do, who don't realize the trouble they get in, they have other plans. He kept on driving, and he was going through the intersection of Hillcrest Road and Sulphur Springs to Dutch Valley Road. This is all in the area of Anderson County, which adjoins Knox County there in Tennessee, and also Frost Bottom Road. That's a good Tennessee road, isn't it? Well, the chase continued, and the deputies they called ahead to Oliver Springs Police Department. Say, hey, we need a little help to get this crazy crook. Well, they wanted to do what they could, and so authorities said the officers deployed spike strips in Poor's path, hoping to stop him. Well, this crazy crook, apparently he sees the spike strips. Instead of driving over them, he decides to drive off the road. And that decision ended him up into a nearby creek. Now, officials said that apparently the crazy crook thought that his car was a watercraft, but that just really did not work out. It actually came to rest in the creek shortly after it entered the water. Deputies then say that Poor exited the disabled vehicle, and he now has a new escape strategy, which officers again found rather humorous. According to the sheriff's report, Poor, he laid down in the creek water, hoping that officers would somehow overlook him or that swimming might improve his odds of escape. But he could not. I guess he could not swim, according to the sheriff's office. And the Anderson County office, they had a little more humor to it when they talked about how this unusual pursuit. In their social media posts, they joked that the Toyota was a sedan, not a submarine, not a bass boat, nor an approved escape vehicle. The agency ended his statement with one final joke aimed at Poor's failed escape plan, asking social media followers for bonus points if anybody could explain where exactly the Toyota's owner manual says that it mentions a creek crossing mode. Well, you can imagine some of the reactions from the people who commented. Somebody said, well, at one point, I'm here solely for the entertainment purposes of the Anderson County Sheriff's Office. Even at the very end of the post, it reads, you can drive, you can run, you can swim, but eventually you're going to jail. Well, thankfully, there were no reported injuries as a result of the incident. And as with all criminal cases, suspects are innocent until proven guilty in a court of law. So this crazy crook who thought that his car was a submarine is indeed Charlie Crimebuster's Crazy Crook of the Week. Now back to our main focus. A jury was paneled to hear the trial. That's the trial between the state there of Texas and Anthony. There is some controversy about this jury, though. The jury consisted of 12 jurors and 6 alternates, but none of the seated jurors were black. However, there was a third of the jury that was of minority. Now remember, Anthony is black, Metcalf is white. There was an instance where one of the black jurors was excused because he stated, quote, unquote, he did not know if he could send a black brother to prison. Well, the defense argued that the prosecutors improperly struck the remaining of the black jurors. But the prosecutors, they argued that their strike and reasons was race neutral. Apparently the judge, John Roach Jr., accepted those explanations. Now, the defense may use this jury selection as an issue on appeal, arguing that those strikes violated the Supreme Court's rule, which prohibits excluding jurors because of race. And some people have suggested that that could become a part of an appeal. But remember, appeals are often difficult to win. So you imagine you have two sides here. The supporters of the verdict, they argue that fairness depends on whether jurors can follow the law and evaluate the evidence impartially, not on a racial makeup of the jury. We don't decide a jury on a racial makeup, but we decide it on the facts of law and evaluating. They did note that both the prosecution and defense participated in the jury selection, and that the judge approved the process. Now, on the other hand, critics of the verdict will argue that having no black jurors in a racially sensitive case raises legitimate concerns about representation and maybe a possible bias, especially because the defense challenged the removal of a black prospective juror. But remember, that juror said he did not believe that he could send a brother to prison. So let's get away from all this race situation at this point, and let's talk about the arguments. The arguments in this case is very simple. The prosecution argued that the stabbing was unjustified, and there has been no court ruling that the jury selection process was unlawful or unconstitutional. The arguments are very simple. They say that the stabbing was unjustified. They say, number one, Anthony allegedly provoked the confrontation. They argued that after he was asked to leave the tent, he refused and he made confrontational statements. Witnesses testified. He said, touch me and see what happens, while reaching toward the bag that contained a knife. They also say that the force was disproportionate. According to witnesses, Austin Metcalf pushed Anthony during the dispute, but prosecutors argue that a shove did not justify responding with deadly force, because Anthony immediately pulled out a knife and stabbed Metcalf in the chest. Austin shoves him, he turns around and stabs him. That's not a whole lot of disproportionate response. They also argued that Anthony was the aggressor. Prosecutors told jurors that Anthony initiated or escalated the conflict, and that multiple witnesses described him as the aggressor in the encounter. Then last, they argued there's no reasonable fear of death or serious bodily harm. Now, under Texas self-defense law in most states, deadly force requires a reasonable belief that it's necessary to protect against death, serious bodily injury, or certain serious crimes. A reasonable belief. Now, he can say all he wants to that he thought that he faced serious threat. But is it reasonable for him to think that? That's what we have to think about with it. Now, the defense, they turn around and they go on the other side, right? They're saying that he reasonably believed that he was about to be seriously harmed. They believe that he created a situation where violence felt unavoidable by him pushing. They argued that the stabbing was not planned, but a split-second reaction to stop an immediate threat. Now, under self-defense law, deadly force is only justified if the person believes that it's necessary to prevent not being shoved, but it's necessary to prevent death or serious bodily injury. Now, they also made a lot about the fact that this guy that was stabbed was bigger and larger than the defendant. The defense says that escalation went very quick and that the defendant had no safe alternative. They also said that there was a lack of an intent to kill. There was no prior plan. There was no motive to harm the victim. Panic or fear-driven was what made the decision. Now, we know now that the jury found him guilty. And we know now that the jury did not buy the defense's stance that it was self-defense. So now comes the sentencing stage. And in this situation, the jury will be deciding what the sentence will be for Anthony. We know now that sentence was 35 years of age. Now remember, the range was between the minimum of 5 years or the maximum of 99 years. So 35 years was what they came up with. And it kind of sits on the low to middle range, not to the extreme of either side. So I guess the real question is, how did they come to the place of 35 years? Now, there was an argument from the defense that this was sudden passion. In other words, there was a great emotional situation. You go back to what happened in Kentucky where the sheriff shot the judge. The defense there is saying that he was under some kind of emotional passion. There was some kind of emotional motive to it, that he just kind of reacted at the situation. And there is in Kentucky more state law that gives much more preponderance to that type of evidence than there is in Texas. But in Texas, there is a sudden passion argument that basically he acted from intense emotional panic during the fight. Now, if they had accepted that argument, then the sentence would have had to been capped at 20 years. So with 35 years, we know that they did not accept that argument in its entirety. They still went to the sentence of murder and 35 years. And when you get down to it, my friend, 35 years probably, when you really think about it, will not satisfy either side. It was too much for the defense and probably not enough for the prosecution. If you are the parents of Anthony, you're saying, wait, this is way too much. Our son was just trying to defend himself. If you're the parents of Metcalf, Austin, then you're going to be thinking, well, good night, 35 years, we'll never see our son another day for the rest of our lives. And this guy gets 35 years, and then he has the rest of his life. So on either side, I'm sure that this sentence would not satisfy all the people on both of these sides. And we're hearing a whole lot of people now that are protesting that this was a racial formed verdict from the jury. So what do you think? I would love to hear what you think about this case. It is a tragedy by all means. There are two families that are devastated, two families that had two young people who had all kinds of potential ahead of them in life, and now that has been ruined by this altercation that happened only a few seconds that took one teenager's life and put another teenager behind bars for 35 years. What a tragedy. What do you think? I'd love to hear from you. Reach out to me, charliecrimebuster@gmail.com, charliecrimebuster@gmail.com. We'd love to hear what you think about this particular case. Well, until this time next time, we'll bring you another crime story for Charlie Crimebuster. Let me remind you, please, 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 stay alert. be safe, and act calm. Chill out. Don't find yourself in the mess that these two families find themselves in over a simple situation that got way, way out of hand. Till this time next time, Charlie Crimebuster saying to you, be safe, be alert. For the life you save, it may be your very own.
You have been listening to Charlie Crimebuster. We would like to thank our sponsor, the Peacemaker Network, and also encourage you to support the first responders, military, and law enforcement personnel by contributing to the Peacemaker Network. That's peacemakernetwork.com. All music and sound effects are courtesy of Pixabay.com. That's Pixabay.com. You can also support us by subscribing to our YouTube channel, tag @CharlieCrimebuster, and then click the subscribe button. By doing so, you'll be notified each time we drop one of our shows. Another more convenient way for you to listen to our podcasts, or for you to say to your smart speaker, play Charlie Crimebuster. If you have comments or suggestions, we would love to hear from you, so please send them to charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Or you can call or text us at 407-917-2211. That's 407-917-2211. Thank you for listening, and we hope that you will join us again for another exciting crime episode with Charlie Crimebuster.